do. All right, well, good morning. I am Attorney Andrea Barnes. I serve as the lead attorney for the Heirs Property campaign for the Mississippi Center for Justice. So excited and honored to have the privilege to speak with each of you on this morning. In reference to the Mississippi Center for Justice, we are a nonprofit public interest law firm who opened its doors in 2003. At that time, the Mississippi Center for Justice had a simple mission, and that was to dismantle the policies that keep Mississippi at the bottom of nearly every indicator of human well-being, denying African Americans and lower income Mississippians the opportunity to advance themselves in the areas of education, financial security, healthcare, affordable housing, and others. And so ultimately, then on this morning, the Mississippi Center for Justice is on the front line and is committed to advancing racial and economic justice. We have 3 offices in the state of Mississippi. I work out of the Jackson office. We have an office on the coast in Biloxi, and we also have an office located in Indianola, Mississippi. In terms of our mission, essentially what the Heirs Property campaign does, and the Heirs Property campaign of the Mississippi Center for Justice was launched in January of this year via grant funding. And so what we do with the Heirs Property campaign is we assist heirs property landowners in keeping, in protecting, in utilizing in their land for generations to come, while protecting it also from the pitfalls of predatory developers, timber harvesters, tax sales, and forced partition sales. Ultimately, in terms of the mission, then it's to protect heirs property and promote its sustainable benefit to historically underserved landowners. Now, we do this in terms of providing direct legal service, and then also we do it through education. So in terms of the direct legal services that we provide, we ultimately seek to prevent and or clear title to heirs property and have the property transferred into the names of the current legal owners. So we have free initial consultations, we prepare family presentations, we draft wills, we probate estates, we do suits, petitions to determine heirs actions, and then quiet title actions. As it relates to the educational component of the services that we provide, again, we do presentations, legal seminars. This is just a flyer of the first webinar that we hosted in April of this year. We had key stakeholders that deal directly with heirs property and the issues that flow therefrom. So we had a Chancery clerk. We had Delmer Stamps with Stamps Farms. We had Gloria Gross with Trustmark National Bank. And then we had Brad Jones with the title company. So in terms of service requirements, of course, one has to complete an application for service. Because we are a nonprofit public interest law firm, there is no cost for attorneys' fees. Typically, but you have to meet of course, the income requirement, which is based upon the federal poverty guidelines. And we typically represent people who want to maintain the property and build a family legacy and maintain generational wealth. So we don't represent an heir who wants to actually force a sale of the heir's property. We don't represent an heir whose end goal is to actually sell the property. And then we don't represent one heir versus another heir where there's a disagreement as it relates to the property. Now, we do know that the USDA has a mediation program that I believe is free, that is designed to help families reach agreement about the next step if there is disagreement. And in Mississippi, that's the Mississippi Agricultural Mediation Program that's located in Jackson through the Mississippi Arts of Cooperatives. And I have their website information and contact information if anyone is interested in that information. So that's who we are in terms of the services, that we provide. And so I wanted to briefly share who we were, but then kind of talk about heirs property, the basics. And then I discussed within this presentation, the human risk and legal risk as it relates to this issue. So let's get started. Well, I'll go back. So on this picture, where we see the person on the tractor or whatever. I always love to kind of use this particular picture because it just reminds me of growing up in rural Madison County in Mississippi. And my grandfather was a farmer. And so one of the reasons that I love doing the work that I do, he died in May of 2019. So it helps me stay connected to him. So he was not blessed in terms of the ability to pursue education and graduate from high school, but he did have wisdom. And so he acquired land when he was a young adult, and he farmed that land and he worked that land. And so he sacrificed. So when I see this picture, I think of, those of you who are on the Zoom today in reference to what you do and the sacrifice and the blood, the sweat, the tears, and working your land to produce a crop, to produce a harvest. And so this work that we do in helping make sure that the title is clear so that you can qualify, for government assistance and loans and different things is very important. So when we talk about the definition of what is heirs property, so for our purposes on this morning, we're going to define heirs property as this: the original property owner dies intestate, which just means without a will, or other valid instrument that transfers the ownership interest in the property to the beneficiaries. So we've had instances where somebody has actually contacted us as an applicant for service where a person died, but they didn't probate the will, right? Or somebody died and typically, and most of the time, they didn't have a will. And so when you don't have a will at your death, state laws of intestate succession are going to actually determine who is going to inherit the property that you have acquired. And so with heirs property, land is owned in common by all heirs, and this is known and unknown. And so all heirs are then gonna own an undivided interest in the land. And this property, I know growing up, I heard the term family land. Did not really understand at that time that they were really speaking about land that was passed down informally from generation to generation without any conveyances. And they were really speaking about heirs property. With heirs property, each independent owner may control an equal or differing percentage of the total property. And typically with heirs property, you usually lack clear title or it has a cloud on the title. Now let's look at, I guess, ownership. And one of the things that when you talk about heirs property or whatever, of course, I think it's inherent that, you look at the human risk and the legal risk, because really with heirs property, there's a lot of issues and concerns and problems that are birthed through a property being characterized as such. So let's look at the ownership of heirs property and what that really looks like. So in terms of ownership of heirs property, each heir owns the property as a tenant in common, and each heir owns this undivided interest. So generally speaking, in heirs property, you can have from 2 to 500 owners of property, right? It just depends on how many generations the land has passed down informally without there being some type of legal action to clear the title to the land and get it into the names of the current legal owners. We actually had a prospective client to contact us. I think it was maybe about 40 plus acres, but in terms of prospective owners, you had at least a couple hundred, right? And that's a lot of people to kind of work through, because what happens with heirs property is, you have all these owners, but you kind of have to do the same thing with following that family tree to figure out who's living, who's deceased, and that person who's deceased, who were their heirs at law when they died, right? And so you have the potential to just, have this complex situation going on to try to get it to clear title, but it can be done. All right. In terms of the ownership interest as it relates to heirs property, no heir can claim any ownership of any specific part of the property, right? Because typically with heirs property, you just have a legal description of the whole. There's not been a partition that would have a separate, where each property would parcel would have a separate legal description. So no heir can claim any ownership of any specific part of the property. As an heirs property landowner, I have a right to leave my share to whomever I designate, right? As an heirs property landowner, I have a right to sell or convey my share of the property to any person or entity without agreement of the other tenants in common. And this is what has led to, I think, a lot of involuntary land loss when you talk about heirs property, because what we know is, in terms of family dynamics, oftentimes it's hard to get two people to agree, and you add in, multiple people, then it can become difficult in terms of there being an agreement as it relates to how we manage the property, what we do with the property. And because I have a right to sell and I don't have to get my other co-tenants agreement, most of the time you have a third party that's not related by blood or family ties that can come in and buy the property. And then what we've seen in the past is then they petition the court to partition the property, right? And the family may ultimately kind of lose it, because at that time, before the passage of the Uniform Partition of Heirs Property Act, courts had this preference of partition by sale. And so it really didn't matter if you had a connection to the land, really didn't matter if you lived on the land. If one person, and if that interest was 1/100, right, of a percentage, if one person petitioned the court to partition, in most instances, that land would be lost. Right. And the family then wouldn't be able to hold on to that, what they would have sacrificed and worked so hard for. So heirs property ownership is an issue. Now, when we talk about common problems regarding heirs property, so of course we kind of touched on this a little bit, where it says decisions regarding land use requires agreement of all the parties. And most of the time when families have heirs property, from what I've seen, they don't really have an agreement. There are instances where you have some people really who don't have a connection to the land. Some of them don't want to sell it. Others want to live on it. Some of them want to farm it. What we also know in terms of common problems is that it's difficult to qualify for loans, grant governmental assistance due to the lack of clear title. We've already kind of discussed that co-tenants could sell his or her interest to a third party, and that one owner could force a court-ordered sale where the property is partitioned. Now, one of the risks, I think, in terms of, you have a question, Mr. Woods?
Yeah, I want to know, would you like to answer questions as you go, or you want to wait to the end, or what's good for you?
Okay, can we save them to the end?
Yeah,
and then
okay,
we kind of go through them. Okay,
all right.
Okay, all right. And so one of the things that we have seen is there are a lot of myths, right, surrounding heirs property. So one of the common myths in terms of heirs property is this: well, you know what? I've paid property taxes on this particular family land and nobody has helped me pay for X number of years, and so the property belongs to me. That is, in fact, a myth. Even if, as a co-tenant, you solely pay the property taxes on land in the state of Mississippi, the land still belongs to all of the co-tenants, right? They just benefit from you paying the property taxes, but the land itself is owned by all the co-tenants. And so when we can think about, I guess, well, the implications of that, or the risk that may be associated with that. And so we know a couple of weeks ago, we saw breaking news in terms of this FEMA requirement, right, as it relates to disaster relief. And it was big because it touched heirs property landowners. So at one point, in order, prior to, I think it was September 2nd, when the new policy was changed, prior to September 2nd of this year, if one had needed assistance for disaster recovery relief, they had to show a deed or some type of formal document that said you, in fact, own the property, right? But there are a lot of people who are in this heirs property dilemma, right? And so they lived on the land. They have maybe a modular or mobile home on the land, but they don't have a deed to the land because it's heirs property. It's not ownership in that individual's name. Well, FEMA removed the requirement that you don't have to now have a deed. You can show other documents that evidence, ownership or you living there. Now that helps people get assistance, but what I can foresee happening is this. What if, say, and so this may be a legal risk for example? What if you say you have a person and the family has agreed, you know what, Andrea, you can live on the land. We live out of state. We don't really want it. And I apply for this assistance with FEMA, and I get the house all spruced up, and I increase its value because it's repaired. And so then when they come home on a holiday, or let's say we have family reunion, and they see all these repairs, and they see, you know, how the house looks so great, then all of a sudden you have those family members who at one time didn't want to have anything to do with the property, now see the value, right? Now they want to either, you know, do something else with the property, or they may want to say, well, you know what, this house, this value has increased, you know, let's get an appraisal done on the house. And, you know, at one time they were talking about just gifting or quit claiming their interest in the home. Now they're saying, no, I want you to buy me out. Right. And unless you reach an agreement as to what those numbers look like, then heirs property landowners could then, even though I've repaired it, it is not mine. It's still not mine. Right. I just have qualified for the funds to actually repair it, but it still belongs to everybody. And so that's a risk, that's an issue. And so, you know, if you find that yourself in that position, of course you want your home repaired because that's where you live and that's your abode, but you just know that down the line, there may be an issue that arises with other family members who initially had no interest in the property, now wanting to come back and have, you know, and claim, you know, the interest that was there. And so these are things as we work through, you know, the problem. So I'm happy that the requirement, you know, has changed, that more people are able to be, you know, get the help and are assisted. However, when I think, I guess, long-term and the implications and what I just, you know, hope that this doesn't also then lead to other arguments amongst family and disagreements, and then ultimately, you know, it may be lost, right? So these are common problems that we associate with heirs property. All right. Now, one of the things in Mississippi, and I want to say as of today, it may be 11, maybe 13 other states who have enacted or passed the Uniform Partition of Heirs Property Act. And this act was actually drafted to stabilize the tenancy and common ownership for disadvantaged families. Because what we know, that research is clear, is that for many decades, state partition laws contributed to a widespread and devastating involuntary land loss among families who own the land as tenants in common. And so this particular law is actually designed to contain legal protections for heirs property landowners, and it's going to address the devastating effects of partition sales. So our governor here in the state of Mississippi, July 1st, 2020, signed into law this particular act. And what it does is it provides specific guidelines for having heirs property partition. And there are three major provisions that I want to briefly discuss this morning in terms of what this particular act does and how it helps heirs property landowners. All right. And so the first thing that you need to know is that, of course, in order for a partition action to be governed by this act, it has to, the property in question has to constitute what's defined, of course, as heirs property in the act. But there are three major provisions. You have a buyout provision, a preference for partition in kind, and a new sales procedure. So let's briefly discuss those and then we'll go from there. So what we know is that partition sales have proved to be devastating to African-American landowners that resulted in forced sales of millions of acres of property and loss of tremendous amount of land, wealth, and family legacy. So there are two types of partition actions. You can have a partition in kind, where you have a surveyor who will come out, survey the land, and then divide up the land, and he or she would then produce a legal description for each parcel. So a partition in kind is simply a division of heirs property in physically distinct and separately titled parcels, with each owner given a parcel in accord with his or her interests. And then the second type of partition action is a partition by sale. And this was also known as a forced sale. So in a partition by sale, you have a court-ordered sale of the entire heirs property by open market, sealed bills, or auction. And so basically what you have in a partition by sale is you're going to have land is sold, and then the proceeds are going to be divided among the heirs based upon their fractional interest. So you can have an heir who has a 1/4 share, and then you can have an heir who has a 1/24 interest, right? So in a partition by sale, you'll get the proceeds based upon your interest, which means all of the interest may not be equal, but whatever one's interest is, that's what you would receive. The next major provision is a buyout provision. So what we know prior to the passage of the act is that heirs property landowners did not have an opportunity to buy out the heir that wanted to sell his or her portion. Typically, what we know prior to the act, what would happen is an heir would petition the court for a partition by sale. Most of the time, you know, even if, like I say, somebody lived on it, if you had everybody else who were co-tenants who wanted to keep it, if that one person wanted to sell it, courts would actually sell it, and it would be based upon like an auction, right? And so you wouldn't get the value of the land, and then you would have somebody who may have lived on the land their entire life who will be forced out of it. Well, the new provision based upon the passage of the act actually enables heirs property owners who did not request the court to partition by sale to buy out the interests of their fellow co-tenants, right? So what that essentially means is it gives the family kind of this right of first refusal to buy the property, to keep it in the family before it potentially may go to an outsider or third party non-family member. Now, although I think this is a major provision and this is a major plus in terms of this act, what I foresee is, and so I think the act probably needs to be tweaked because, you know, this is great, but you still have to be in a position where economically, financially, you can pool together your resources to be able to buy out the family member, because now the buyout is going to be based upon market value, right? Rather than like auction. So at the end of the day, the question becomes, well, when you think about who will benefit from this, right? Is it 9 times out of 10, it may not be your low income, underserved people, right? It's going to be people who maybe your middle class or, you know, other people who have the means to buy it out. It's a great provision because it at least gives landowners in the family a right to see even if individually I couldn't do it, maybe together collectively we could try to pool our resources to keep it in the family. But what I know is that most heirs property landowners are land rich and cash poor, and they just may not have the financial resources to be able to buy it out. But this is a major provision that was placed here in an effort to assist with it just not going to a third party, but being able to stay in the family. And then the last part of this provision is a preference part for partition in kind. So what happens is if the buyout remedy doesn't resolve it, then courts have to look at the totality of the circumstances. And this is really big because before, courts did not consider that. So when they look at the totality of the circumstances test, what does that really mean? Well, they have to look at economic and non-economic factors. So if I have an emotional attachment to the land, if I have this connection to the land, if I reside on the land, if I pay property taxes, other expenses associated with the land, the courts then now consider all of that before they make a determination that they're going to sell it. So now, since the passage of the act, instead of it being this preference towards selling, there's a preference for, if we partition, let's partition in kind, where we're able to divide it out amongst the various families versus then selling it and dividing proceeds, right? So that's huge in terms of where we are, right? It does in fact help to protect heirs property landowners. And then the last thing I'll say in terms of the act is that they have this new sales procedure where it's placed on the open market. You have this sign that says, you know, the land is here. And so the open market preferred sales procedure is a design to mirror the traditional real estate procedure. So you have a broker and it goes through the market just like it would if it, you know, was, let's say, commercial or whatever. So the great thing about the new sales procedure is that the price that is paid for the property is actually the value of the property. What's heartbreaking is to know that pre-act, when property was sold, like I say, it was more like this auction, kind of like this debtor creditor thing on the courthouse steps or whatever. And you just did not get what the property was worth. And so you have, all this acreage being lost, and then the families still weren't able to recover financially, right? From this asset. Now it's going to make sure that if it's sold, you actually get what the value of the property is. And so this, and I put this sign land for sale on here because the act requires a notice. And that was one of the things too, pre-act. A lot of times it was the 9th hour before families knew anything about the property, being sold, or, the partition action. Now, the public has to have this enhanced notice regarding to the partition sale, and it's actually exposed to the market for a longer period of time. And so that's another, protection. All right. And so the next thing today I wanted to kind of discuss, and I'm looking at my time, is estate planning and why that's important, or whatever. And so I know majority of you are, business owners, and you have farms and entrepreneurs. And so, when you think about your plan, your blueprint, your business plan, your guide of how you're going to operate your business, how management decisions are going to be made financially, what that looks like. When we talk about estate planning or succession planning, we're just talking about the act or process of becoming beneficially entitled to a property or property interest of a deceased person. And so we know that estate planning is also referred to in the farm transfer context as succession planning. And this process actually strategically distributes your assets during your lifetime, and then also while you're incapacitated, because at the end of the day, what we know is life happens, and we have to be in a position where we plan for risk, where we plan for the unknown, where we plan for the unforeseen. No one wants to think about, well, if I become physically or mentally incapacitated, what happens to my farm? What happens to my business? What happens to my assets? And so when you start to think about estate planning, one of the things about estate planning is life planning, right? And a lot of people would say, in terms of life planning is something that should begin early in adulthood. And so one of the things we know is that even in life planning or estate planning, we know that it can be simple or it can be complex. And that just depends on the size and the composition of your estate, your family, your situation, and your business situation. And so what am I saying? Well, what I'm saying is there are no two families that will have the precisely the same set of circumstances, but there are some basic estate plans that most people follow, right? And so when we think about succession planning and estate planning and life planning, how do I sustain? How do I keep? How do I prolong the assets that I have acquired over the lifetime? Now, one of the things about this picture, it just kind of depicts to me tranquility and peace of mind. And that is something that an estate plan, offers. If we just think about women and how women control 1/3 of the total household financial assets in the US. However, majority of women don't have an estate plan in place. And then we think about even those who may have an estate plan in place don't really understand how it works or where their assets are going to go at their death. And so what we have to know is that, one, it's time for us to take control of our estate plan in order to achieve our financial goals and pass on wealth to the next generation. So some of the goals in terms of estate planning and its importance is it ensures that you have the necessary income and resources to live. It ensures that upon your death, your assets go to the people and/or organizations you intend. It minimizes estate taxes, fees, disputes, confusion, and any associated costs. And so what am I saying? One, when you start, I know we're talking about risk and management and different things. It is important to start now thinking about, how do I manage my finances? How do I protect my assets? And how do I have this clear path for distributing those assets in the future? So our challenge on today is, one, to know our financial assets, to protect those assets, and then to plan for your financial assets. because this is something that is certain. When you fail to plan, state law is going to determine who inherits. And so when you fail to plan, you subject you and your family to risk. Well, what does that look like? And so in Mississippi, there are categories of takers, or in terms of heirs at law, right? And so this is the thing that we know. Most people assume that if you die tomorrow, all your assets are going to be distributed to your surviving spouse, or if you don't have a surviving spouse, to your children. But what we know is in reality, that may not be the case. And so a human risk in failing to plan or having a estate plan is this. I have known a lot of people or clients to contact me to say, you know what, Ms. Barnes, we've been separated for about 12 years. And then, one of the spouses died. Okay, well, in Mississippi, Mississippi first doesn't recognize legal separation, but this is the thing. Even if separated for 12 years, 20 years, I've had clients that have been separated for 30 years. At the end of the day, when that other spouse dies, even if you're separated, your surviving spouse will inherit. And that is a risk, right? And people don't know that. They think, well, you know what, we're separated. He won't get it. She won't get it. That's not true. In Mississippi, even if you are separated, if there is no final adjudication or final judgment of divorce, then you can subject yourself to working hard and thinking, prior to your demise, that, you know what, my children will get everything, when that's not the case. Without a plan, without a will, without, some type of life estate deed that maybe would have said, during your lifetime, you have the property, but if your death, it goes to so-and-so. When you fail to plan, there are inherent risks that are involved. And that's why succession planning, life planning, estate planning is so very important. And one of the things I have found too is you have a lot of people who say, so let's say Jane and John were married and they have 3 kids, Bev, DeVoe. Well, Bev dies, right? And Bev has a spouse and kids. Well, a lot of times when you ask prospective clients, well, who are the deceased? They fail to mention the surviving spouse of Bev, right? But they'll say Bev had kids. Well, in Mississippi, if there is a surviving spouse, it's not only the children of Bev, but it's also the surviving spouse of Bev. One of the things we also run into and find that people need to be concerned about and know that this is a risk is that on obituaries, we like to include our goddaughter, our play daughter, our godson, and this, and so one of the things with an intestate estate, if you had to, let's say, file an estate action with somebody that did not have a will, the obituary is a document that courts use as evidence of heirship. And so, in the petition, we allege 5 kids, but on the obituary, you have 10. So the court is then left to wonder, well, who are these 10 people? Because Attorney Barnes, in your petition, you only say the decedent had, 5. And so that's something that I know culturally we do, but we need to become more aware of, that it can create problems in the event someone fails to plan. And, family are oftentimes, we're just trying to be nice and list everybody that, the person had an impact on their lives. That's fine, but don't put it in the obituary. Don't list this as a surviving person if in fact it's not a biological and or adopted child, okay? And so, like I say, when you fail to plan, Mississippi law or state law, and not just Mississippi, state law is going to determine it. I use Mississippi here as an example because I practice in Mississippi. We can go to the next slide. And so, I know all of us are busy. All of us have our to-do list. But one of the most important things that I think we can do to protect our families for generations to come is to have a well thought out and up-to-date plan. So it's time for us to plan to help eliminate the risks that are associated and inherent with not only heirs property, but just property in general, just living, in general and acquiring assets. So the first step is to kind of take inventory, create this list of assets, think about the needs of the family. This is a myth. Some people think that, so when I say think about the needs of the family, think about what you have. Most people have, life insurance. If you have young kids, you're thinking about, well, who should be their guardian if something were to happen to me, right? Document your wishes so that if something were to happen, people know who it is you wanted to take care of and be the fiduciary over your children. When you think about legal directives, you're thinking about a trust, a medical directive, this power of attorney, right? And you're thinking about all these different things. I've known clients who've had, let's say, a power of attorney for asset management, and they decided who will manage their assets, a power of attorney for, a healthcare directive who would decide, what happens in the life or when it comes to making those decisions. These are the things that we need to talk about, even though we don't like to talk about them. It's necessary, it's needed, because when you fail to plan, again, all these risks, legal and human, come into play. And then the next thing I think the step is to name beneficiaries. And so, you check your retirement and your insurance account and make sure those are updated. I know people who, maybe list beneficiaries on various documents or whatever, and then may go get a will and sometimes forget, oh, wait, so-and-so is on that. Keep up with the different retirement accounts, insurance accounts, different things that you have acquired and who those beneficiaries are. And if you want to change those, to make sure they stay up to date. And then the next step would be to seek professional help. So that's an estate attorney, an attorney who specializes in estate planning, succession planning. You need a tax advisor, a professional financial advisor, planner, an accountant, insurance agent. And then you review the state's estate tax laws. And then you review your plan, because life happens, life changes. And so every couple of years, reevaluate, reassess the plan. And it's essential, I think, to coordinate your beneficiary designations forms with your estate plan. So make sure they're the same, because retirement accounts, life insurance policies pass per the beneficiary designation on file with the company, not according to your will. So you need to make sure, if you have a will drafted, that the beneficiaries listed in the will that you want, are the same as the ones you want to take on the retirement accounts, the life insurance policies, or whatever that, it is that you have. One of the things that you also can do is with financial institutions, they have these payable on death beneficiaries, right? And so you can make sure that with your financial accounts that you already have this designated beneficiary, because what happens is this: if you fail to plan and designate a beneficiary, if there is money in an account that's solely in your name, the bank is not going to let your family get that money, right? 9 times out of 10, they're going to require that an estate be open, and they have somebody presents with what's called letters of administration. And that's the legal document that gives that person the authority to act on behalf of your estate. So to reduce the risk of having to do that, payable on death beneficiaries is an avenue that you need to consider. And so when we think about the basic estate planning documents, one, is not the attorney's job to make decisions about your goals, but it's actually the attorney's job to provide the pros and cons, the different options, narrow down your individual options so that you're empowered to make the final decision. And so this is kind of just a list of basic documents that everyone should have in place to help with to avoid the human risk. We have a will. And of course, the will is the legal document that directs how your financial and physical assets are going to be distributed at your death. And then the living will is a term that's commonly used, but that's advanced directive that states, my wishes for end of life. And then of course, I talked about already this durable power of attorney for healthcare, where you appoint one person or more than one person who's going to make decisions on your behalf in the event you become physically or mentally incapacitated. And then, of course, advanced documents of an estate plan could include a trust or some vehicle for charitable giving. And we just know, just basic, in terms of basic definition of a trust, it's just a way to hold and manage and distribute your property. It's this custom designed bucket, so to speak, that's going to hold and take care of your assets during your life and then distribute them after your death. And so most of the time you find trusts are used together with a will as part of the estate plan. There are several different types of trusts. And so it's important to speak with an estate lawyer who can answer your questions and walk you through this process so that you have peace of mind to know, if on tomorrow, if anything were to happen, you know where your assets are going, you've made plans for that, and you know how to, your family is going to be sustained and what's going to happen, with your business. So when we talk about ways to prevent the risk, right, or help diminish the risk, of course, we talk about a valid will, a revocable living trust that can be changed during your life. We talk about family land trust or LLC agreements. Most of the time, family land trusts are with nonprofits, but these agreements kind of discuss the use and operation, management, and longevity and sustainability of what you have. Again, the life estate deed is that deed where you say, this property is mine at my death. I reserve a life estate. You convey it and reserve a life estate, which essentially means during your lifetime, it belongs to you. At your death, it automatically goes to someone else. One of the things I will say, and then in Mississippi last year, they passed a law in terms of the transfer on death deed. I think, though, the legislature is going to take this one back up because there needs to be some changes as it relates to it. But one of the things that I recognize and understand with doing heirs property work and just dealing with landowners is most of the time, especially elderly or more seasoned landowners, there is a lack of trust within families, a lack of trust as it relates to lawyers and other professionals. And I know, that there's history in terms of that or whatever. And I say that to say my grandfather, whom I love, that I talked about at the beginning, I talked to him because I'm a first generation lawyer. I talked to him, my grandmother, years ago about estate planning, life planning, right? They needed a will, and I went through all the different documents, healthcare directive, this, and this. And although even when I was in law school, my granddaddy would, always call me my lawyer. But he didn't hear his lawyer on the will part, right? And he didn't want to do the will. He just was adverse to a will. But he did hear me in terms of you guys need to do, because what they did is they bought up land, and they, as their children, got of age and married or whatever, they gave them X number of acres to kind of begin their family and build their homes on. But then he still had acreage left that needed to be divided. So what he did do, he listened to me, and we got a surveyor in to come in and survey the land, and the remaining acreage of the land, and divided amongst the children. And so they gifted it or quitclaimed it to their children during their lifetime, right? So so although he didn't draft a will, which is what I wanted him to do, he still was able to life plan and gift his real property during his life, such that at his death is nothing to fight about, is nothing to argue about, because it's all been distributed, right? But I say that to say there are many people that I meet where trust is an issue, and we're trying to move past and be proactive to gain the trust of seasoned and elderly people as it relates to, because one of the things we know is, just through history, land has been taken, and land is something that, our people sacrifice for. It has value. It means something, right? And so we do the work to help people maintain, protect, utilize, and keep their land. But life planning is a part of that, right? So how do I avoid being in an heirs property situation? I life plan, I succession plan, I estate plan, and I do the things to ensure that my family does not have to worry about losing the land, or I ensure that who I want to gift it to, that happens. And so what can you do as you begin to think about the things that are needed? Well, I can begin now to kind of, growing up, especially when you got in like high school and it was time to start dating, my family, I would say, who are the people? Know your people, right? So you won't be dating your cousins and your whatever. So, but it's important to know who we're connected to. And so a family tree is important to begin to say, okay, let me trace my lineage so that I can figure out who owns what, right? Or you can even start developing your own family tree with you and your spouse, or just you if you're single and not married, and what that looks like. And then you can start thinking about, what I found is a lot of people come and they actually have, their family members may have a will, but they just held on to the will. They've not probated the will. Well, it may be time to administer the estate and probate the will pursuant to the wishes of the deceased person. Or to protect yourself, you may need to do a determination of heirs, where we determine the heirs at law of the deceased. And then we educate families, right? Maybe it's time to begin the conversation of trying to educate your family about the importance of sustainability, longevity, maintaining the wealth, building the legacy. And then you talk about this partition in kind and partition by sale. So this is the way in which I think we can help alleviate and diminish the risks that are associated with heirs property if we're proactive and begin to have these discussions, right? Well, tell me about so-and-so, or, dad, I know my granddad, but who's my great-granddad? Who's my great-great-granddad? Because I've seen these from 1905, 1908. I mean, I've seen these from the 1800s. And so, and like I say, just generation after generation after generation, it passes. And so you need to be able to know who these people are. And there are a lot of websites for free that kind of help you with a family tree. And then of course there are websites that help you with tracking, what that family tree looks like. And this is just an example of a family tree that I like to use as a visual. And so you start with that individual, and then you just going down the tree in terms of children, and and because it helps you see where people fall, and not only where they fall, what percentage of the property one may be entitled to based upon the tree. So in this particular family tree, you have 2 children, and those two children had 2 children, right? And so based upon if those people were living or somebody was deceased, would determine what percentage that they would get. And so I hope on this morning, it wasn't overload, right? But I did at least want to share the importance of where we are. One of the things that we know with President Biden and his administration is that he's very committed, to heirs property. I mean, they just sent out the, I think it was the heirs property relending program and other programs, I think geared toward farmers that fall in this situation that they own, heirs property, in an effort to assist and help. And so I think that heirs property is a hot topic right now, but it's something that, really should have been hot years and years ago, but we're just thankful it's hot now and it's on the minds of our, elected officials and or whatever. And they're trying to do things to help assist people that fall into this category. And quite honestly, there's a lot of people. And so, the need is great. And so I just hope that we've shared something that you feel that was valuable today as it relates to things that you can be doing. In terms of my contact information, we actually have an heirs property hotline, which is the 877-952-4347. And then if you want to have an inquiry, you can email heirsproperty@mississippicenterforjustice.org. And then you can also go to our website, because we have a lot of information on it. We actually also have, I think, the first webinar that we've done, you're able to kind of, watch it. If you have other questions, and then you can, of course, I'll get my paralegal will get the email at the HP, but then she'll forward it to me. So, but if we would love to converse, have an opportunity to talk to you, I guess, specifically about your situation, because there's, everybody's not the same in terms of facts and what you may need. But, if you do have questions and different things that we were unable to cover in our time together this morning, feel free to reach out to us. And so I will stop sharing my screen and we can answer some questions.
Okay. Let's see where I started at.
Let me see.
Okay.
So in terms of, I know one of them says about the bill number in terms of the Mississippi. So give me 1 second. And I know it's Senate bill, but I just want to give you the right bill number. So hold on 1 second. Senate Bill 2553, and it was effective July 1st, 2020. Again, that's Senate Bill 2553.
As someone says, we are currently in this situation. I encourage everyone to get a will. Even if it's a simple one, that is notarized, then fill in the county where the land is located, and keep copies and issues for them desired heirs. So that was just a statement.
Okay.
Someone asked, I think it was one they said in Texas. Okay. I work for a nonprofit farm connected to a food bank in Texas, working mostly with Hispanic, Latino, Latinx. Do you have any information for these services in Texas?
I can not right off, but email me and we can get you to the correct persons who are handling heirs property work in that state.
Okay.
Yeah. So send me an email and I'll follow up.
Okay. Okay.
Let's see.
A lot of comments in here.
Okay. Yeah. And I'm trying to do it too.
We're getting a lot of good praises in here.
Okay.
So I had a question about the heirs. So
Okay.
So you said in the just say if there were like 10 acres and 6 heirs, and there hadn't been any type of partition to even divide the land up.
Okay.
So let's just say one of the heirs wants to sell their share within that property, but it hasn't been partitioned. Well, it hadn't been sectioned off or anything like that. What could that particular heir do?
Okay, so you don't necessarily have to partition it before the person sells, because if you have 6 heirs, everybody has a 1/6 interest in the property. So what that person would be selling was his or her 1/6 interest, whatever that is. Now, ultimately, at some point, the heirs may want to divide the property up so that they have a specific legal description for their acres. But if initially you're not there, then you don't have to per se survey it before I'm able to convey it, because what I'm conveying is just my interest, whatever that is. Does that make sense?
Yeah.
Okay.
Yeah. I mean, well, it was my situation. I had an uncle that came to me that wanted me to purchase his land, his interest in land, because he didn't want to sell it to anyone else. He wanted to sell it to someone in the family. Okay. But because it wasn't sectioned up or anything, I didn't know what his interest was within it.
Right. So he only had, so let's say if he was that one, if it was 6, he only had his 1/6 interest. So what he was selling to you was his 1/6 interest of the whole, right? And until you're able, but then what you guys could have done, so he still could have sold you that. And then you later, now that you have his 1/6 interest, and let's say you may have acquired other family members' interest, right? You can say, well, you know what? I want to divide my portion, what I have. Then at that point, the surveyor could come in and survey out your portion. However, one of the things is, of course, the family would have to agree in terms of where your portion is, right? Because the interest is of the whole. Right. And so, once the surveyor, let's say, partition it in 6 parcels, somebody got to determine if I'm gonna get the part by the lake, if I'm gonna get the part by the, this. You see what I'm saying?
But what if they don't want to agree to do this?
Okay, so that's when you file something with the court, right? So initially you try to work it where the family, works to resolve it amongst the family. At that point, then you will file it with the court, and at that point, the court can order a partition in kind. Or, you see what I'm saying? But, I think the better practice is to start with the family to see what you can work with through the family. And then if, worst case scenario, if that's not it, because, now, like I say, especially if the state has passed the Uniform Partition of Heirs Property Act, at least you're covered that nobody else outside of the family has an opportunity to buy, to do anything until you have an opportunity to do it. And it sounds like you're not necessarily looking for a partition by sale. You just want a partition by in kind, where it's partitioned, and the court will make a determination whether or not that's the best route to take or whatever. And even with the question of, because everybody wants to make sure in terms of what their parcel is worth, that it's substantially the same. We can have an appraisal come and and especially if the acreage is pretty big, and try to divide it where it's equal in terms of your percentage, but then also in terms of value. So you can work through, I think, through that. It's just knowing what to do and who to contact to be able to do it.
Okay. I think someone wants your information provide your information again.
Okay, and I'm going to give you, I gave you a hotline, but I'm just going to give you my direct number, which is 769-230-8531. Again, that's 769-230-8531. And that's a direct number, so you'll get me. And like I say, in terms of specific questions to your individual scenarios, that's more, I guess, 101 or whatever. So just give me a call if you have like specific questions that are fact specific, if that makes sense.
All right. Any more questions?
And one of the things I'll just share this. I like to, be transparent. My grandmother is still living. She's 93. I'm just so happy that they decided to convey that property because, she's always kind of been vibrant or whatever, but now she's at a point where, you have to take care of her. And so my aunts and uncles and the grands take turns, sitting with her and taking care of her, whatever. But it looks like as of late, she was like diagnosed with dementia. And, she told me just Sunday, my mind, something's going on with my mind. It's not quite right. And a couple of months ago, perfect. You know what I mean? Just own it. And I said that to say, or I shared that to say that, life happens. And so it's so important to have something in place. It's so important to have a plan, not just at death, but just physical or mental incapacity, your inability to make decisions, your inability to appreciate and know the assets that you've accumulated and what you want to do with them. It's important to now start thinking about worst case scenario. If I'm unable to take care of me, if I'm unable to handle my business and take care and operate my farm, what happens not only to me, what happens to my farm, what happens to my family? It's important to try to eliminate all those risks. Okay. So I can go on and on about that, but I'll pause there. Again, I'm just thankful for the opportunity to have shared on this morning. You all have my information. Feel free to give me a call, and I, look forward to developing a rapport and collaborating and working with you all.
All right. Thank you so much, Attorney Barnes.
You are welcome.